shore of Lake Erie. And in 2016, I had the honor and privilege of serving as OREA's president. Today, I'm joined by a very special guest who is probably no stranger to you if you've participated in our past webinars, or if you've taken an outreach session. Leanne may have been your instructor in that outreach session. So I'm pleased to welcome to today's webinar, backed by popular demand, Leanne Southgate, who herself is a former broker of record. She was the president of her local real estate board, and she actually was curriculum manager for the OREA College, and then a subject matter expert at the Real Estate Council of Ontario, and we're thrilled to have her back at OREA as one of our very own subject matter experts, and as I mentioned, a very popular outreach instructor. Welcome to today's webinar, Leanne, and thank you for joining us.
Good morning, Ray. It's great to be back. Happy Monday.
Thank you. Let's get started, everyone, with a quick reminder that today's webinar is for informational purposes only. If you have transaction-specific questions pertaining to a transaction that you're actually conducting, you should refer those specific questions to your brokerage management. Perhaps you need legal advice or other professional advice. Here's today's agenda. First, we are going to answer a lot of the questions that were outstanding from the December webinar when we introduced our new forms, our revised forms, new clauses, and revised clauses. So if your question didn't get answered, we're going to let everybody hear those questions today and answer them for you. Throughout today's presentation, feel free to type any questions you may have regarding the content that we're discussing today in the Q&A function in the Zoom platform. We're going to do a deep dive on verifying information, the consent to advertise, representation agreements, most commonly being the BRA and the seller representation agreement, commonly referred to as the listing agreement. The brand new form, which is my favorite new form that OREA created for 2025, the commission agreement. We're going to talk a lot about something that's an integral part of TRESA, and that is disclosures. And then if there's still some questions that remain unanswered, we're going to do our best in the time remaining to answer those for you. So let's kick things right off with a member question that we heard a lot in our last webinar and by way of email since. So Leanne, I'm going to pose this question to you to kick things right off. Why do you need permission to publish the sale price when the public can see anything on the MLS?
First of all, Ray, we have to realize on the MLS system, consumers don't see those sale prices. We're talking about the database that realtors use. That information is just for you. So what do consumers see? They can see something brand new, sold data, that can be uploaded on realtor.ca. Now, this is something new coming into Ontario. It's already in existence in a couple of other provinces, but it would require the consent to publish that on realtor.ca. So where does all of the requirement for consent, whether it goes on the MLS system or it goes on realtor.ca, come from? That's due to privacy legislation. So the consent that you get on your listing agreement and buyer representation agreements will only be to publish that sold price on the MLS system that you see. Additional consent would then be required to place it on realtor.ca.
When you say additional consent, Leanne, I know that a lot of members publish just sold with a photo of the house on Facebook or Instagram. Is that something else that requires this additional consent you refer to?
It sure does, Ray. And later on in this webinar, we're going to rip that form, consent to advertise, apart, and we're going to show you all kinds of examples of what you're advertising and who needs to consent.
Awesome. So let's get started. And before we do that, Leanne, a related question that we heard from a lot of members, let's take a look at it. Does it comply with TRESA if consent for multiple representation or consent for advertising is obtained on the confirmation of cooperation and representation.
Okay, Ray, on this one, the key word is consent. So let's take a look at what consent is actually required. For multiple representation, you have to, first of all, disclose how things change when you're operating under multiple representation as opposed to single representation. That ties back to how do these services you offer change? How do the duties you owe, your obligations, how do they change? So first of all, you have to make that disclosure. And then second of all, they have to consent to proceed. And you can see in the word for advertising, we've got underlined consent. So with the confirmation of cooperation and representation, the answer lies right in the title of the form. Confirmation, you are confirming previously agreed upon terms. You are not getting their disclosure of the information and consent of that disclosure on the confirmation of cooperation. And just very quickly, Ray, I see in our chat box, Patricia has a question about multiple representation. She's wondering if the agent has both seller and buyer, is it multiple representation? Absolutely, and it won't matter whether it's brokerage representation or designated representation. If you are representing more than one client, so that could even be competing buyers, that will be multiple representation.
And I know we're going to do a deep dive on the topic of multiple representation later in today's webinar. And we're going to direct our members to some outstanding pieces that OREA has authored with regards to multiple representation to help our members comply. Now, before we move forward, Leanne, probably when REBA was practiced prior to December 1st of 2023, we disclosed multiple representation on the confirmation of cooperation and representation at the time of the signing of an offer. And you've walked us through what you need to do when you find yourself practicing multiple representation. A key aspect of the practice of multiple representation is timing. And by that I mean, when you as a realtor realize that you are involved in multiple representation, you have to stop everything you're doing immediately. You have to slam on the brakes right then and there when you know you're acting in multiple rep, and do those things that Leanne reminded us of. That is, let the clients know your interest in this property constitutes multiple representation. It creates multiple representation. This is what multiple representation looks like. This is how the services and the representation that I'm providing to you change. And lastly, as Leanne already reminded us, we need consent in writing to proceed. And Leanne, some things in TRESA say we submit a document to our clients to ask them to acknowledge it. With regards to multiple rep, does the legislation specifically require that that consent be in writing?
Absolutely, and as you can see on the screen right now, we've got a portion of the general regulation dealing with multiple representation. And you can see the second part, B, that's underlined. A, you have to disclose it. B, after they've received that disclosure, they must consent. If they do not consent, you may not proceed under multiple representation. So that's a key reason why Ray has said the timing of all of this is important. It used to be okay at the time of the offer because you were discussing it all along, but this was a major change in TRESA. You don't get the written consent, you do not proceed.
So I know another member question that I see in the chat, Leanne, is, well, if I'm a listing agent, can I have the required consent signed at the time I list that seller's property for sale? Or likewise, when I'm representing a buyer, can I have the buyer consent to multiple representation at the time they sign that BRA, which might be weeks or months in advance of an actual offer hitting the table?
The quick answer to that is absolutely not. Multiple representation consent is specific for every instance. So they cannot provide you consent in advance. They have to provide consent based on the current situation with multiple representation. They may agree to multiple representation, but suddenly the buyer is their neighbor and it's their children. And they go, you know what? I don't want to consent for multiple representation with this specific buyer. So although I'm okay with it generally, not in this instance.
Excellent example. So Leanne, before we switch to our next slide, would it be fair for me to summarize that the reason we're introducing the confirmation of cooperation and representation, considering that we've already got consent for multiple rep on other forms, in the case of a buyer and seller, we know those are forms 325 and 326. Can we consider the confirmation at the time of an offer signing or presentation to a seller to be a reminder of that which they already consented to?
Absolutely. As we say, it's confirming previously agreed to information. However, in terms of the multiple representation, because of that scenario I just gave you, you want to absolutely confirm at the time of the offer that their consent is still in effect for the trade to proceed under multiple representation.
Right, because we know that clients can change their mind. They're entitled to change their mind. So let's leave this discussion with regards to the confirmation here. We'll address it later when we introduce to you the additional documents that OREA has created for your consideration. But staying on this particular topic, let's look at our next slide. And that is, how can a buyer's agent, Leanne, verify taxes when the municipality will not disclose this to anyone other than the owner? So before we hear your answer, we know that it is our responsibility, even when we're representing a buyer of a property listed for sale with another brokerage, not our brokerage, a competing brokerage. It's our obligation when we represent that buyer to make sure that which is indicated on the MLS feature sheet is in fact correct. Isn't that right, Leanne?
There's an obligation on every agent in every transaction, no matter whether you're full service or limited services, you still must verify information. There's good ways to verify information, such as source documents. So for property taxes, how could you verify this as the buyer's agent? Well, first of all, ask the listing agent for a copy of the document that they should have used to verify the property taxes when it was placed on the MLS system. You can use MPAC to get the assessed value, apply the mill rate, but realize that that may not be the final tax. There could be other local improvements tied in that a mill rate times the assessed value doesn't get you. Speak to the municipality. What do they actually need so that you can verify that information? But at the end of the day, it's up to every agent to verify information for every client they have.
When I'm representing a buyer, Leanne, and you have the property listed for sale, I just can't accept what you've got on that MLS feature sheet as the gospel. You're suggesting that I need to verify that which you told me as the listing agent on behalf of my buyer client.
At the end of the day, if it all goes bad, did you do your job? So taking for granted what's on an MLS is assuming that the other agent has done complete due diligence, and that doesn't always happen. So to protect yourself, verify.
And you've talked about getting the tax bill from the municipality, or rather from the seller in this particular example. And you also suggested multiplying the mill rate by the assessed value. And sometimes the information provided in the software we use to get that information is incorrect. So the gold standard really is to get that source document. In this particular example, Leanne, the final tax bill, right?
Yeah. One mistake that agents will sometimes make is they're taking a listing, and let's say you're taking it in the spring, and the tax bill that the owner has is an interim tax bill. The budget hasn't been finalized. They have not set final taxes. When that final tax bill comes in, if you've put the interim taxes on, or if you use 2024 taxes, go back and update your listing to reflect 2025 final taxes.
Excellent. It's a very expensive question. It's a very expensive lesson not to verify information. So in that regard, Leanne, let's look at a recent discipline decision levied upon a member for failure to verify. This decision was handed down from the Real Estate Council of Ontario. And the seller, or excuse me, the listing agent in this particular example simply asked the seller, hey, what are the taxes for your property? And the listing agent in this example accepted what the seller said without verifying any source documents, didn't use MPAC, didn't use Geo Warehouse, didn't ask for the actual tax bill. So what happens? Prior to closing, the buyer's lawyer requested a copy of the MLS feature sheet, which some lawyers representing a buyer will request of you, and realized at that time the tax information provided on the MLS feature sheet was actually, in fact, $1,000 short. So the buyer complained to the Real Estate Council of Ontario. This went to a full discipline hearing. And Leanne, I'm going to let you walk us through what this expensive outcome was for this agent.
Well, it was expensive, and it's also time consuming for the realtor. You would have spent much less time verifying the taxes than what you did with your interactions with RECO. And on the surface, we say, well, it was only $1,000, so what? But in actuality, this was double the amount of taxes that was reported on the MLS. The MLS said they were $1,000, and they were just over 2,000. So that's a huge increase in what that buyer was expecting. So where does the discipline come from? It stems out of the code of ethics. And in this particular one, the listing agent, the decision was based on not providing conscientious and competent service, and as well as not trying to prevent error or misrepresentation. So not doing your job resulted in $9,000 in fine and go back to school.
Ouch.
Take a course. Ouch is right.
Leanne, would this extend to a seller saying to the listing agent, hey, Leanne, in 2015, I put a brand new roof on this house. And then that's what the listing agent, in this example, you accept it as the gospel. And then the buyer discovers after closing, after they've moved in, that the roof is leaking and the shingles were actually installed in 2010. Is that going to get you the same kind of expensive penalty from the regulator in the example of a seller who made improvements to their property?
Absolutely, because it would be the same code of ethics and fractions. And on that particular one, it might even be misleading or false advertising, because your MLS listing is a form of advertising. And when you say new roof, do you mean the plywood on the roof and the shingles, or do you mean just the roof shingles? So there can be even more added in your scenario, right?
Yeah, I know of a realtor who put on an MLS feature sheet, new roof. Buyer moves in, discovers that the sheathing, the plywood underneath the asphalt shingles was not new. And this went to court, and the judge found in favor of the buyer. The agent in this particular example had to pay for brand new sheathing, and again, more new shingles, because the shingles had to come off to be able to install that plywood. So the lesson learned here is always verify any information that you receive pertaining to a property by way of source documents. So let's talk about how we can verify that information. But before we do that, Leanne, let's take a look in the chat. Are there any outstanding questions that you've noticed?
There's several of them that talk about VOWs, so brokerages sharing the sold price. If you want to touch on that, Ray, that's a common question I'm seeing.
Excellent question. And I, as I mentioned, am a broker of record, and we do have a VOW, which stands for Virtual Office Website. Clients can sign up to receive sold data from us by way of technology. When a property, let's say in the community of Port Rowan, sells, that client who signed up to receive the sold data from my virtual office website receives it magically by way of technology. But they had to sign up to receive that information. They had to agree to be a client of my brokerage. They had to agree to very strict rules with regard to how they use that information. That information is to be for their sole and exclusive use only, for helping them with their own real estate transactions. They agree, when they accept those very accept rules, not to post that sold information in a public format like on social media. And I know why this question is being asked, because we see consumers who receive that sold data from a VOW and they post it all over social media, Facebook, Instagram, what have you. They are in fact in violation of the VOW agreement that they signed up to. So a lot of members automatically assume that it's the real estate brokerage who provided this sold information doing the wrong thing. It's not assuming that they did in fact have their clients agree to those strict rules. It is the consumer who takes that information and shares it against the rules that they agreed to. So let's help our members, Leanne, learn how to verify information. And this is one of my favorite forms that OREA has created. It's called the Residential Information Checklist. This by no means is a brand new form, but it's been slightly revised with a couple of minor changes for 2025. As an example, the changes are so minor. The word client was changed to consumer, because we can also use this information checklist when we're helping a self-represented party, for example. So this form is simply an information gathering tool. It is simply for you as a realtor to walk through, in the case of a seller, questions about their property, so that you can make sure that the information that you are providing to prospective buyers for the property is in fact up to date. This form is not to be provided to a buyer. This is for your brokerage file only. And I love this form because it will alert me to some red flag issues that require me to do some more due diligence. I work in an area of Ontario which is heavily cottage country. And some crazy things happen in cottage country. People build, by way of example, decks on the back of their cottage without a building permit. And that can be a headache. That can be a real hiccup for us on closing if the buyer's lawyer figures this out. So one of the questions on this checklist is, have you made any renovations, additions, or improvements to the property? And if that seller says to me, yeah, I built that new deck on the back, the next question on this checklist says, well, did you get a building permit for that? And if that seller says to me, no, we've got to figure out what we're going to do, knowing that that deck was built without a building permit. And we won't take a deep dive into what those options are today. We can answer those another time. But that's what this form is intended to do. Gather information and alert you to those red flags. Now, there's a parallel form called the Seller Property Information Statement. And I'm going to throw it to you, Leanne. Now that I've done a highlight of what's on Form 820, can you explain to us what the difference is between the information checklist that we have on the screen right now and the very equivalent SPIS, the Seller Property Information Statement?
Well, Ray, first appearance, it would lead you to believe there's absolutely nothing different because really the questions are identical on both forms. It's the legislation behind that really identifies the difference between the SPIS or the residential information checklist. So let's go back to the SPIS. We ask sellers to answer the questions, initial in the appropriate box. You would then have that on file if a member had a buyer interested in reviewing that SPIS, they would contact you and you would provide that SPIS to that individual. However, under REBA, it said, unless otherwise directed by the seller. But under TRESA, it says, when they ask, you provide it. There's no longer that unless portion in the registry, in the regulation. For the checklist, you are asking questions, you are identifying the applicable answers, and you keep it in your file. It's showing that you've done the due diligence. You've done the asking of questions. You're verifying the information. So the SPIS, if there is one, you must let folks know there's one that exists. And the minute they ask to see it, you must provide it. But the checklist stays in your file.
So the real estate board that I belong to, Leanne, has a field on the MLS data entry form that gets extended onto the MLS feature sheet on the MLS system. And it specifically asks on our data entry form, is there an SPIS available? And if there is, I check yes. Then I upload that SPIS as an additional document right onto the MLS. Then, as the listing agent, I've satisfied my obligation pursuant to TRESA to make buyers and buyers agents aware of the fact that there is an SPIS. I said yes to that particular field on MLS. It is now the responsibility of the buyer's agent to get that from the MLS as an additional document. So our MLS systems help us comply with this new requirement, this somewhat new requirement from within TRESA. And you already answered the next question. I jumped ahead a little bit there, Leanne, so thank you very much for helping us with that. Let's jump to a what-if situation. And we sometimes, as practicing realtors, have sellers that say to us, look, I want to sell my property as is. And when I hear that from a seller, a prospective seller, I dig deeper. I say, what do you mean you want to sell your property as is? And sometimes sellers will say, if there's anything that they discover that's wrong with the property, I am not in a position to make any improvements. They have to buy it as is. However, sometimes sellers will say, I want to advertise my property as is because I don't want to make a disclosure of the basement leaking every time it rains. So Leanne, the question is, if a seller says, Ray, I want to sell my property as is, so I'm not required to make disclosures, is that acceptable?
First of all, Ray, under your fiduciary obligations to that client, you're supposed to follow their instructions. You obey them. But that doesn't mean you obey an unlawful instruction. And asking to hide a latent defect is an unlawful instruction that you do not obey. If there's any pushback, you advise that client to speak with their solicitor, get all the risk, get all of the information of not making that disclosure informed to that client. If you don't make those disclosures, then you are in much trouble as that client. There is obligations now new under TRESA that did not exist under REBA. And remember, TRESA is for realtors. So the obligation for the realtor to make those disclosures is new. and we have Form 299, latent defects, to make that disclosure. A seller has legal obligations for disclosure. Selling it as is not a way to circumvent that obligation to disclose. So, and selling it as is, it doesn't mean buyer beware and you don't have to verify information for that buyer. Verifying information has nothing to do with selling it as is.
We're going to do a deep dive later in today's webinar about the disclosures, I believe, of which there are 11 within TRESA. So stay tuned, everybody, because we're going to walk you through what those disclosures are and how to make sure you comply with making those disclosures the right way. Any questions in the chat that you're able to see that are outstanding, Leanne?
Just a few, going back to one about the roof and the no permit, and then it was the deck. The obligations for what you should actually be doing in terms of tracking that down rate and verifying is kind of a theme going through the chat box right now. What we're looking at is, so if there's no permit, and in Ray's area, I've also traded in cottage country a lot. I don't know how many times those improvements have ended up on property you don't own. Because if it's facing the water, that could be where you don't own the shoreline. So the problems are, you've got a deck not built on your property. What are the effects of that? Might be tear the deck down. So the SPIS is a great gathering tool along with that checklist. Sellers do not have to complete an SPIS. It's optional. There are some areas where agents rely on a seller completing that every time they take a listing, but it's up to you, it's up to your brokerage to decide whether you want to use the SPIS or use the checklist. At the end of the day, you have to prove you did your job. You have to prove you did the due diligence. You have to prove you verified. So one of those two documents could be used. A seller doesn't sign the checklist, but the seller does sign the SPIS. But it's optional to use either one.
In the event of a complaint, and let's say that complaint is made to the regulator, is the Real Estate Council of Ontario, Leanne, not going to say to you as the listing agent, illustrate to us how you discovered facts about this property?
You have to prove you did your job. So source documents. If they say, I put new roof shingles on, ask them for the invoice from the contractor that installed them. If they say, I hired a contractor to build the deck, get the invoice from the contractor. Keep those source documents. If there's a complaint that you didn't verify, you need to prove the steps that you took. You can't take their word. You need the documents.
And because there's so much discussion in the chat, Leanne, regarding this, let me share with everyone a real life scenario that came back to haunt our brokerage. It was resolved satisfactorily, but people say, well, Ray, how in the world would it be discovered that that deck on that cottage was built without a building permit anyways? Fair enough question. But we had a property listed for sale, and it sold. And prior to closing, the buyer's lawyer reached out to the seller's lawyer and said, yeah, there's a survey for this property that's 20 years old. On that survey, there's no deck. However, this lawyer, and he was sharp, the buyer's lawyer, he went on, he looked at the property from aerial photos online, Google Earth, I assume, right? You know how you can look at properties from Google Earth. This lawyer actually looked at the property as part of his title search on Google Earth, compared it to that 20-year-old survey, and he realized, hey, 20 years ago, there was no deck on this property, but on Google Earth, there is a deck on this property. And then he asked the municipality if there was ever a building permit issued for that deck, which there wasn't. So the seller had to scramble and remedy this situation, which involved getting a building permit, having the building inspector come out, look at that deck, make sure it was installed according to the building code. It was stressful, it was aggressive, it was last minute. So that's how these things rear their ugly head. I know it sometimes seems this will never happen, but it does, and it can. Let's leave that discussion there, Leanne, and shift gears. Something we're going to spend a lot of time about, and that is consent to advertise. Now, as I think you mentioned previously in today's webinar, when we list a property for sale, the seller representation agreement, the listing agreement, has a clause in there titled marketing, wherein the seller gives us permission to advertise their property for sale. And when it sells, to put a sold sign on the property. That's the consent to advertise for the property while it's offered for sale. But what we're referring to here, when we introduce to you Form 170 that's been substantially revised, is advertising sold properties. We're not referring to advertising the property for sale. You've achieved that consent with your representation agreement with the seller. So I just want to remind everybody, this consent to advertising that we're about to take a deep dive on refers to sold properties. So, Leanne, we often as realtors receive offers, and there's a clause inserted onto the schedule of the agreement of purchase and sale that says something very similar to the example that we've got displayed on the screen. That says something similar to the seller and buyer consent to the brokerages named herein, including any sales representative or broker, to advertising the property as sold. So my question to you, Leanne, considering what Tressa says, can I obtain the consent of the buyers and sellers in the body of an APS on the schedule?
It sounds like it would be an easy and quick method to obtain consent because everybody's signing the agreement of purchase and sale. But it's not really a best practice. Best practices is not to insert into an agreement of purchase and sale anything relating to the brokerage terms. It should only contain the terms between the seller and the buyer. Imagine explaining to your client how a deal didn't go together because of a clause that benefited the brokerage. Once that change to the offer has been made, that party is no longer obligated to the offer. So if you stroke out that advertising consent within the agreement of purchase and sale and you send it back to the other party, that change alone has released the other party from their obligation to that offer. Not a good practice.
And you know, some members might be saying, Leanne, that's a stretch. No seller's going to cross out a consent to advertise in the body of an offer. I've been a realtor for 29 years. I have personally, on occasion, witnessed that happen. And some members may have read about a case in which the Schedule B wasn't initialed by the buyer in a transaction, which had clauses on it which were truly beneficial only to the brokerage. That transaction didn't close. The buyer refused to close because they said, we didn't agree to this thing. Our initials are not on that schedule. The seller sued, and the buyer won that lawsuit. So, you know what? Don't take the risk. While 99% of the time it may not happen, there are circumstances where it in fact does happen. So let's take a look now that we've heard that it's a best practice not to insert this type of clause in the agreement of purchase and sale. Let's see how we can do that. So as I previously mentioned, consent to advertise is not a new form. It's been revised substantially, I would suggest, for 2025. I think it's much more user-friendly. I like to say that the way this form is laid out holds our hands as members and really tells us when consent to advertise is required and by whom. If you look at the vital notes and cautions in bold on this particular form, it tells us who is required to consent for this type of advertising. Is it just the buyer? Is it just the seller? Or is it the buyer and seller? So Leanne, let's use an example of something we see all the time, and that is where realtors advertise on social media, on Facebook, by way of example, using a picture of the house with just sold across the front of that house, and they promote it all over Facebook. Does that require consent to advertise?
Absolutely it does. You're identifying that the property's been sold. The only thing in your listing agreement would be your sold sign. Outside of that sold sign, any other advertising requires consent. And as you can see on the form, depending on what exactly you're advertising, when the advertising is taking place, will dictate who actually must consent. And when you need consent from the other brokerage's client, the code of ethics shown here requires you to use that other agent to obtain the consent of their client and not go directly unless the other agent has given you permission to contact their client directly.
So let's use another example. Sometimes we see sold riders affixed to the top of a for sale sign that says something like sold for 100% of asking price. Now, you said, Leanne, that the listing agreement under the marketing clause gives us consent to put a sold sign on that property. Do I need consent for a rider that says sold for 100% of asking price?
Absolutely, you do, Ray. And next in our PowerPoint are some really good examples, some illustrations of what's being advertised and who needs to consent. So absolutely, that rider, consent is required.
Because the listing agreement said we can put a sold sign. When we say for 100% of asking price, we're giving away a term of the agreement. Is that correct?
That's right. The term, 100% of the asking price sold in 10 days. That's all terms of the agreement.
I've probably jumped ahead by using some of those examples. So let's actually look at some very common examples where we do in fact need the consent to advertise. And as we mentioned, consent to advertise form 170 is really helpful and easy to use because, as I mentioned, it holds our hand. So Leanne, I'm listing a property for sale today. When I list that property for sale today, why can't I just get form 170 signed at the time? Can I?
It's not practical to have it signed at the time because, again, this can be transaction specific, just like consent for multiple representation. They may decide, depending on the sale price, that they've decided not to consent for that sale price being advertised. So it typically comes along with the offer because then they know the situation surrounding their consent. It takes effect after it's firm and binding. So the advertising wouldn't take place during any conditional time period. It's after it's firm and binding. And according to the form, it's for any type of advertising and there's no expiration date. So if you want to restrict the type of advertising or if you want to put an expiry date on that, there's a comment section on the form and you can use that to put a little more parameters around the consent that you're obtaining.
I just jumped into the chat, Leanne, and in response to what you just said, that the advertising is without expiration according to the form, some of our very smart members have said, well, sometimes we use a just sold on Facebook by way of example, and we know that our posts on Facebook live in eternity. It stays there forever. However, that would mean that just sold resides on Facebook after the property is closed, after the buyer becomes the owner. So if we're using a just sold on social media, Leanne, we probably, if we're not going to delete it on the day of completion, also get that buyer to sign. Is that what you're suggesting?
Absolutely. If moving forward, that advertisement will be in effect after the expiration date, get consent up front from that buyer. And even though they've given consent they can ask you to take the advertising off. And you would be expected, even though you have their consent and it was without expiry, they can change their mind. You would be expected to comply with their request.
And as a broker of record, I have in fact received telephone calls from buyers who said, hey, we're the buyer of 123 Main Street. There's photos of our house on social media. We want those taken down. They didn't consent to it. So it does in fact happen. So let's take a look at some of those examples. And I think we've already talked about this particular one. What consent for advertising is obtained in a listing agreement? We've referred a couple times already to the marketing clause in the body of the seller representation agreement. So we'll leave that there and look at another example. And this example, I really like, or this what if scenario. So sometimes we often end up selling a property to one of our buyer clients that is a self-represented seller. And a self-represented seller is more commonly known as a FSBO, a for sale by owner, right? We may want to, after the fact, after we put the transaction together between our buyer client and the FSBO, ask the seller, can I put a sold sign in your front yard after this transaction becomes firm and binding? And remember, if this seller is a true self-represented seller, we don't have a listing agreement with them, do we? They are truly self-represented. They are totally on their own. We don't have an agreement with them that allows us to put that sold sign in their front yard the way our listing agreement does. So Leanne, while we're on the topic of 170, I think everybody probably knows, we're going to suggest you can use 170 to get that consent from that FSBO, that self-represented seller. Can you walk us through that?
Sure. So on the form, there's 3 general sections, and this would be on the lowest one, number 3, where it says, you can see the red X, that you're obtaining consent to identify that the property is sold. And then we've given you some examples, and one of those is the sold sign. You don't need that when you're the listing brokerage because you have it on your listing agreement, but you do need that when it's self-represented.
And I see in the chat, some members have said, well, Ray, previously you guys have told us to have a self-represented seller sign a listing agreement. And that's true. That's not always the case. Not every FSBO is going to sign a representation agreement, but we've got good news for you. Help is on its way later in today's presentation to get paid when a self-represented party is involved. So we're really excited for that part of today's webinar. So Leanne, we've talked a little bit about postcards and just sold on Facebook. On the screen, we have a postcard that's distributed by way of mass mail through Canada Post. Does a postcard in the mail with a photo of the house and saying that we just sold the property for $1 million require consent to advertise?
It sure does. And on this one, we've got 2 different things that we're advertising. One is that the property is sold. The other one is the sale price. So you would actually on Form 170 require 2 different sections completed. The first one for the sale price, and that is both seller and buyer. The last one identifying that it is sold, and that'll depend on when the advertising is taking place. If it's before the transaction closes and this card is going out, seller. If it's after transaction closes, it would be the buyer.
Let's look at what's next. And we're going to use an example of the listing brokerage advertising without the sale price. So let's use the example of the photo of the house with just sold across it on Instagram.
So on that particular one, if you're advertising any terms associated with that offer, so on the display here, it shows sold over asking, so that's a term. Sold in 10 days, that's a term. Anything associated with the offer would then require both seller and buyer to consent to that advertising.
I didn't set the table for this question very well. I didn't look over at the sold rider where you had underneath there sold over asking. So a sold sign on the for sale sign by itself is okay because we got permission in the seller representation agreement. But I just want to make it clear, it was my oversight that I didn't mention this particular rider, as you see in the illustration in the upper left, says sold over asking. And as Leanne just so rightfully said, that is a term of the agreement of purchase and sale. That term was a contractual piece between the buyer and seller, requiring both of their consent to say something like sold over ask. All right. Sometimes, Leanne, we have buyer clients say, Ray, take a picture of us holding the sold sign in front of the house we just purchased. They ask us to do that. And so we take a picture on our smartphone and then we text it to them. But then when we return to our office, we post that picture on our own social media channels. Now remember, it was in fact the buyer who said, Ray, take a picture of me. Do I require consent from that buyer when they asked me, Leanne, to take their picture?
Yes, and this is actually part 2 on Form 170 where this consent is obtained. And this is where you can identify a party to that trade. You must get the consent of that party. So it won't matter when the advertisement is taking place. If you can identify the party, you get their consent.
Ironically, I just saw a Facebook post over the course of the weekend where a young couple just bought their first home. Their representative posted a picture of them on social media, and the buyer herself said in the comments where she saw her picture, oh my goodness, I can't believe this happened. This was a surprise for us to tell our parents. They may have heard it from our realtor rather than from us. So there's a real life example why you should have this discussion with your clients to make sure it's cool that you're going to post their photo in front of the new house that they just bought. And I know we've talked a lot about this one already, Leanne. It's what if you can identify the property in the photo. So I can tell by looking at the photo on Facebook that that's a very prominent house in the neighborhood in which I live. So I'm just using a photo. I'm not giving any terms. I'm not giving the address. I'm just using a picture of the house. Does that require my permission if I'm the client?
Yeah, it sure does. And on this one, this depends on when the advertising takes place. So before closing, seller, after closing, buyer.
All right. So we gave a lot of great examples there. We tried to compile examples that we see out there in the marketplace all the time. There's probably some others that you have questions about, and we'll be happy to answer them at the conclusion of today's presentation. And remember, you can always email us at standardforms@orea.com with your questions related to all things forms and clauses. We're shifting gears now to representation agreements. Leanne, while I've been talking, have you had a chance to look in that chat to see if there's any pressing questions that we're seeing over and over?
I think we're good on this one, Ray. Maybe a few specifics about the form, but remember this recording will be available. If you want to go back on this section of the recording to see specifically what I need for what, then you should be able to get that input then. Or email us, standard forms. standardforms@orea.com. Always happy to help.
We're going to promote the hub, which is something that we're incredibly proud of at OREA, that are 1 or 2 page down and dirty, raw and real documents that explain 24 different topics in real estate. So stay tuned for us to introduce some of those to you in a minute. So, Leanne, let's take a look at the seller and landlord representation agreements, and specifically the commission clause in those representation agreements. We've had a couple minor changes to the commission clause, but they have significant impact. Can you let us know what those 2 changes are that we have highlighted in red, underlined in red on the screen?
This was changed just to clarify because we would get feedback from our members where sellers were still a little confused over the amount of commission payable. So it was changed where the total amount of commission is identified. So when it's listed and it's sold, This is the commission payable by the seller. We then separate out that should there be another brokerage involved in the transaction representing the buyer, out of the total commission we identified above, this is the amount that will be paid to that cooperating brokerage. So it's not adding the two up, 4 apples and 2 apples. They're not paying 6 apples, they're paying 4 apples. And if there's another brokerage involved, 2 of those apples will go to that other brokerage.
Excellent example, and this was a great clarification on the form, because as you said, Leanne, I've had sellers, even when I've explained this particular clause to them, using your example, where I put 4%, 4 apples total commission, and 2 of those apples out of that 4 are to a cooperating broker. They'll still say, in some instances, does that mean we're paying 6 apples, Ray? This was increased clarity added to this form, very helpful. Let's look next, Leanne, to another addition to the commission clause. This is the last sentence. This is a brand new sentence added to the commission clause. Let me pose the question. Where does the commission clause identify the commission payable when there is no cooperating broker? So by way of example, let's say I have a property listed for sale, Leanne, and I'm charging total commission of 4 apples. And 2 of those apples are offered on the MLS to a cooperating broker. But then the buyer of the property doesn't have a cooperating broker. Why? Because that buyer self-represents. It's a self-represented buyer. So to the specific question, where or does it indicate in the commission clause what the total commission will be when there is, as per my example, a self-represented buyer?
It's right in there on the same clause, the very last sentence, saying that that total commission, the 4 apples identified earlier, you will still pay the 4 apples if there is no cooperating brokerage. And that also means that the buyer could be represented by someone within the listing brokerage. It doesn't mean that they're necessarily self-represented. The buyer can have representation. And as the listing brokerage, if you're also representing the buyer, you are not a cooperating brokerage. You are still the listing brokerage.
So Leanne, let's say a member's business model is such that they'll charge 1 apple 1 point less if they double end it. Now we've got this sentence that says the total commission, even if there is no cooperating brokerage, is as stated as the total commission. How would we contract for that agreement we've made with that seller that if it's double-ended, as an example, it's a point less?
That's what many agents refer to as a collateral agreement. And that must be within your representation agreement and most likely found on the Schedule A. There's no room in this commission clause to identify that. You would identify any circumstance where the 4 apples aren't going to be charged within the representation agreement and on the schedule.
Now, I know somebody's going to ask, well, Leanne, now you're saying in the commission clause that it's 4 apples. The total commission is the total commission, even if there's not a cooperating brokerage. But you've just said now on the schedule, you're agreeing to something less. Now we have conflict between the pre-printed portion and that which we inserted on the schedule. Do we have a problem, or do we have something else in the agreement that clarifies this situation where the pre-printed says one thing, the schedule says another?
You're covered. We have a clause on representation agreements. We have a clause on the agreement of purchase and sale. And it generally states that anything that is added in will supersede the preset print, which means we all agree to whatever we've added in because it takes precedence over whatever the preset print is.
And I think we call that particular clause conflict or discrepancy. If members want to go read that clause, I think that's the title of it, the bolded portion of the clause. I think it's referred to as conflict or discrepancy. All right, so guess what I just did, Leanne? I jumped ahead again and I asked a question already that we have on our screen. You've talked to us about throwing that in the schedule so we can move forward. And here is where we introduce our first piece in the hub, one of 24. So Leanne, while we're on this topic of seller representation agreements and the commission clause, let us know what we should expect to see in this particular guidance piece.
Well, this tears that commission clause on the listing agreement apart. There's a lot of moving pieces in that. There's a lot of different aspects of it that you need to clearly understand in order to explain that commission clause to your client. It includes the holdover provision, scenarios around that holdover provision to understand when it kicks in and how it kicks in. So a lot of good stuff in that document allows you to have a more easy conversation with your client, explaining what their obligations are for commission.
So it's a real deep dive just into the commission clause all by itself in a seller representation agreement. So I would encourage everybody to look at it. As I mentioned previously, there's 24 such pieces in the hub. We're going to promote a couple more of them, but they're all there at OREA.com/the hub for you. Now, here's a brand new form that came out in 2025. We titled this the Representation Agreement. And so this form is incredibly beneficial and helpful in a circumstance that isn't captured by way of a seller representation agreement or a buyer representation agreement. So one common question that we were asked when TRESA was rolled out 13 plus months ago is, well, do I need a representation agreement when I do a letter of opinion? Just a simple letter of opinion? And if you look at the regulations within TRESA, the answer is absolutely yes, you do. So a listing agreement, when you're simply doing a letter of opinion, is superfluous. It's got a lot of overkill in there, a lot of stuff that we don't need for the simple presentation of a letter of opinion, right? We're not going to do marketing, and we know there's a marketing clause in the listing agreement. So if we're asked to do a letter of opinion and we understand that our obligations are to in fact have a representation agreement, OREA has created this one pager. It's simply a one-page document, as you can see on the left-hand side of your screen. And what Leanne is going to do is quickly walk us through the body, the meats and potatoes of what's on this representation agreement. So over to you, Leanne.
Under TRESA, there's requirements for a representation agreement. So in some ways, this aspect looks like what was on any representation agreement. You have to have a start date and an end date. So if you're doing a letter of opinion, maybe the start date is today and the end date is a couple of days from now when you're going to have the letter of opinion completed. You still must get the initials for the term of the agreement. If you would like it to become a designated representation agreement, then there's a line there to fill in the designated representative's name. If it's left blank, then it's a brokerage representation agreement. Then we're also going to take a look at how to complete this in terms of describing the services, because that is huge when completing this form. And then the last portion is what your fee is. So it's very easy to complete, but there's a couple of really key considerations that you need to be aware of when you are actually completing it. So we're going to show you how to complete this for a letter of opinion.
All right, let's do that. And I've already asked this question and Leanne has already gave us the answer, but I know we want to talk about whether or not a letter of opinion, a representation agreement rather, is always required when completing a letter of opinion. And Leanne, that answer depends upon whether or not the letter of opinion is intended for a trade in real estate. So can you elaborate on what I mean by a trade in real estate and representation agreements for letters of opinion or not?
Sure. So that's why I said the reason behind the letter of opinion is key to understanding the completion of this form and what your obligations are under TRESA. So we'll start with what's not in relation to a trade in real estate. So if a lawyer is settling an estate and they just want an opinion of value of what this one property is within the portfolio, they're not selling the property, that's not in relation to a trade. There's no transaction being contemplated at all. It's not going to lead to a transaction. You do not have to have a representation agreement for that purpose. The second example, the seller asks you to provide a letter of opinion, so it gives them an idea of if they were to sell, what the property would be worth. There's the potential for a trade there. Therefore, that one is considered in relation to a trade in real estate. Representation is required to provide that service of a letter of opinion. And as well, RICO's information guide would be required prior to providing that letter of opinion. It's like any other service that you provide, RICO's information guide right up front.
I see a question from a couple of members, Leanne, that says, if I'm unsure of whether or not the letter of opinion is for a trade, is there any harm in having the representation agreement signed?
Actually, it might be a best practice, whether it's in relation to a trade or not, to have this representation agreement completed. Because when the brokerage gets paid, they need a source document to track why the brokerage received those funds. So this could be used as that source document. The only difference then would be whether you provided them with RICO's information guide or not.
And hey, it wouldn't hurt to give the guide when you're unsure. Better to be safe than sorry, right?
Absolutely.
So let's look at completing Form 218, and you indicated already that we're going to walk our members through how to complete this very easy peasy form. So Lee, over to you. Just give us a high level summary of what I think you already did, because you mentioned that we insert the fee, and if it's a brokerage representation agreement, you leave the designated representative field blank, but if you are in fact a designated rep, you're going to insert your name there, and you talked about the expiry. So I'm happy that I'm not the only one that jumps ahead in today's webinar.
On this one, Ray, if you can give me a click, we've actually completed the form as a visual for our members.
Very good. Yeah, so there's a real life example, an illustration of the form completed. It's similar to all of our OREA forms. I don't think we'll have any challenges with completing this, but if you have specific questions, remember, reach out to your brokerage management. Now, Leanne, sometimes people won't charge, members won't charge for a letter of opinion. They may do it complimentary. Does that change things? So if I'm not charging a fee, do I have to go through the process of getting this rep agreement signed?
The only thing that changes is that you wouldn't have a trade record sheet because there's no funds. You wouldn't have a trade record sheet for providing a letter of opinion. And just because you had the representation agreement, you wouldn't have to identify that there's a fee associated with it. If you give me a click, Ray, you can see where we've completed the form. And the only difference is it's a fee of $0. You put complimentary, but nothing else changes on that form, and your obligations don't change, whether or not you've charged a fee.
So other examples of when we may use this representation agreement, Leanne, might be for the simple preparation of a CMA. It might be a best practice to, in fact, have that representation agreement when you're not charging a fee for simply doing a CMA. Can you think of any other examples, Leanne, where this representation agreement may come in helpful to a member who wants to make sure that they've in fact complied with TRESA and their obligations to explain representation?
Any type of service that you're offering would require a representation agreement. So let's even think about leasing. Let's say you've got a landlord and they want you to perform credit checks on tenants. That's a service to that landlord, but you don't have it up for lease. They just want you to do a little bit of property management stuff. So you could even use a representation agreement for something like that. It's not just doing letters of opinion.
We receive a lot of this particular question at OREA from members, and that is, if I'm going to host, I guess the real question, can I host an open house for another real estate brokerage? So let's say, by way of example, Leanne, I have a property listed for sale. You, as a realtor, work for another real estate brokerage. You don't work for my company. Yet you want to host an open house on my listing, or I've asked you to host an open house on my listing. You can't do that unless you have representation established with that seller. Would this representation agreement satisfy the requirement for representation agreement in that example?
It makes a really good start, Ray, but remember, there's also a few clauses within the listing agreement that wouldn't be found on here, such as indemnification and insurance. So you might want to beef up that representation agreement form 218 to accommodate that particular scenario.
Excellent example. Oh, I did it again. I jumped ahead.
Not quite. One more slide after this one and you did, but this is a slightly different question. It's somebody within the brokerage, other than the designated representative, hosting that open house. So it's a service. Anyone in the brokerage can provide that service. RICO has a great bulletin on what you need to do if someone other than the designated representative is the one who's the host. First of all, you have to have a conversation and an explanation with the seller. And then you have to have written direction from the seller. When's the open house taking place? Who's hosting it? Are there any restrictions when showing the property? So a good RICO bulletin when someone else within the brokerage is hosting the open house other than the designated rep.
Excellent. Thank you, Leanne. And now I've jumped ahead too far. In the interest of time, let's keep plowing forward. Here's a great question. There's a self-represented seller out there, otherwise known as a FSBO. They agree to allow you to conduct an open house for them. Will 218 cut it?
Nothing will cut that one, Ray. You cannot provide that service to a self-represented party. RICO has another good bulletin on dealing with self-represented parties. Because the open house is a service, you can only provide services to clients, and you can only provide assistance to a self-represented party when it's as a service to or incidental to the services you're providing your client. So you cannot interact with an SRP if you don't already have a client.
That was our one and only trick question in today's webinar. Now, here's a question that I also saw in the chat already, Leanne. Can I use 218 instead of a full-blown listing agreement to place a mere posting on the MLS? For our members' benefit who aren't totally sure of what a mere posting is, that is in fact a listing agreement, a seller representation agreement taken by a real estate brokerage where there's really limited services provided. Generally, it's simply the posting of that listing on MLS. A real surefire way to tell that it's a mere posting is you'll see in the brokerage remarks something to the effect that the listing brokerage will not hold deposits. If you want to present an offer, present it directly to the seller. Don't bother us as the listing brokerage with offer presentations. If you want to negotiate your commission, you need to do that directly with the seller. So with that little bit of briefing behind us, Leanne, in those mere postings, will 218 do it for me?
The best move would be to check with your board or association for what they expect to have to post something on the system. There's a lot of clauses on listing agreements that aren't included within Form 218. Maybe the best practice is to use the Form 200 or 271 listing agreement and add something on the schedule to identify what service only it is that you're providing to that client.
That's really sound advice. Now, while we're speaking of services, Leanne, OREA introduced 4 brand new clauses for 2025 pertaining simply to services. We've got them displayed for our members on the screen. When would we use each of these new clauses, Leanne?
Well, the first one is where it was maybe an SRP seller. You brought the buyer there, and they would like to have some representation, but not a lot of advice. And be aware that this would then create multiple representation to enter into that listing agreement with that SRP. But if you wanted to limit the service to only bringing an offer from the buyer, you could insert the first clause into that seller representation agreement. Now, these can also be used with buyers. You can turn it around, seller to buyer. So let's do that with number 2, where you're not going to provide any market analysis. Let's say you're working with this buyer. They have a house finally come up in the neighborhood that they want to buy in. It's the perfect house. They don't care what price they pay for it. They want the house. You want to prove that you've provided those fiduciary duties to them, working in their best interests. Maybe paying that much for the house isn't in their best interests. You could insert number 2, that you're not providing the analysis, you're not providing them anything in terms of the proper price for that property. If it goes bad, they complain, they paid too much, you would want to have it documented that they understood clearly that you were not providing any market analysis. 3 and 4 can kind of go hand in hand. And have you ever had an offer that didn't go together? It was a really good offer, but the seller didn't accept it. It's now a month later, they've had no more offers. They have to move now in 30 days. They come to you and they say, remember that buyer? Could you go back and see if that buyer is willing to put an offer in? Here's my price. Let them know I got to move in 30 days, so that's the closing date I'm looking for. Can you go back and find me that buyer again? You would want to amend your listing agreement to include the last 2 clauses, because you owe them confidentiality. And they're now telling you you don't have to keep that confidential information. So there's a lot of good scenarios for these, and you can change them to buyer if that's your situation.
4 really great clauses to cover your backside in those unique situations. I think those are fantastic. And you raised a very interesting concept, that is of confidentiality. And so I think it's important that we discuss that a little bit before we move forward, Leanne. So during the currency of a listing agreement, which was for $1 million. I had the seller's property listed for sale for $1 million. And during the currency of that 90-day listing, I learned that their bottom line is $900,000. I also learned that they're really motivated to sell because they're getting a divorce. They do not want this house hanging over their heads anymore. They can't stand living together any longer. My listing expires, though. I don't sell it within that 90 days. And so they relist with another real estate brokerage. As luck would have it, I secure a buyer for my former listing. But remember, when I had it listed for sale, I learned their motivation to sell, and I learned their rock bottom number. But I'm not representing them anymore. My listing expired. I'm now representing a buyer for that former listing of mine. Can I tell my buyer client, Leanne, the rock bottom number is 900 and these 2 are divorcing?
Well, I'm going to sound like Lou Radomski right now. The answer could be maybe. If they give you written instructions that you don't have to keep confidential information confidential, and it would have to be specific on what the seller is releasing you from, everything remains confidential. And I like to describe it that when you're in a listing agreement, you're working in a silo. Everything you've learned stays in that silo. even though you're no longer in the silo, everything you learned stays in that silo. So you would not be able to tell your buyer client any of that confidential information you learned while representing that client. There is no expiry date on your confidentiality obligation.
Excellent. Under multiple representation, Leanne, and this is multiple rep 101, how are the duties owed and the services provided impacted?
Under multiple representation, you can see here it's underlined. You have to treat the parties in an objective and impartial manner. Part of getting consent is explaining how those services would change. So we've provided an example here. When you're providing comparable sales to help the buyer or the seller come up with an appropriate price, under single representation, you provide them the comparables, you dissect the comparables, and you say, in my opinion, the correct price to offer is X. Under multiple representation, you still provide them those comparable sales, but that's where it ends. They need to dissect, they need to come to their own conclusions. You cannot offer them any advice on that price.
So you're the designated rep for a seller, Leanne. You're also designated rep for a buyer who wants to buy that seller's property. The buyer makes an offer. The seller turns to you and says, Leanne, we like this number, but do you think the buyer will pay more? What should we do? Should we counter? What are you going to say?
What I'm going to say is, let's put the number down on the offer and see what they do.
Because in multiple rep, as the regulation states that we've got highlighted on the screen for you, you must act in multiple rep, as Leanne already said, objectively and impartially. And I think we have an outstanding document in the hub strictly about multiple rep, don't we, Leanne?
Absolutely. It's a newer one that's been posted, tears apart multiple representation and what your obligations are.
We're probably going to show you that in a minute or two, and I probably jumped ahead again. So we've talked really at a high level, Leanne, and I introduced an example of what the limitations under multiple representation are. Let's talk about that in a little bit greater detail and how we've captured that in our representation agreements. Specifically, let's talk about that 6th new bullet that we've added under the multiple representation clause in our rep agreements.
So the first 5 bullets, we're all familiar with them. They've been around for many years, and it basically is illustrating that being impartial and treating everyone in an objective manner. So the first few bullets talk about, I can't tell you any purchase price or any accepted price of the other party. I can't disclose any motivation of that party. They're getting divorced, they're moving across the country, cannot make any of those disclosures. I can't give you advice on how much you should offer or how much you should accept. And this one changed when TRESA came out. You can now, under TRESA, disclose the terms of other offers under the seller's direction. So we can share the substance of offers, but only when the seller's directed you to do that. So you can still do that under multiple representation. But the 6th bullet, we wanted to make it absolutely clear that if you had information on what a buyer had previously offered on a property similar to that seller's, under multiple representation, you may not make that disclosure to the seller. So it was just for clarity, keeping the contents of that offer confidential.
So if a buyer client in multiple rep, Leanne, made an offer in competition on another property and was unsuccessful, yet that seller, where that buyer was unsuccessful, said, I want you to tell the buyers that the buyer in question here put $1 million on paper. When we go to another offer for another property, you're saying we can't disclose that to this next seller, right?
That's correct. And depending on how you obtained that information on what the buyer had previously offered, If you were under a representation agreement, and remember, brokerage representation agreements still exist, so if you became aware of that, it was confidential information under that other offer. Even under single representation, you wouldn't be able to disclose that because confidentiality continues. But what this clause is saying, if you were privy to that information and you didn't obtain it in a way where you were under a representation agreement, under multiple representation now with this offer, you cannot disclose that price to the seller.
Can you avoid multiple representation, Leanne?
Yes, you can. And it might be a best practice for some brokerages under designated representation agreements to have a little bit of guidance within the brokerage on how you can actually avoid it. You cannot avoid it if you have one or more parties under a brokerage representation agreement. That will be multiple representation every single time. It can be avoided under designated representation agreements by having different designated representatives for the seller and the buyer. And if you can avoid it by having different representation agreements, you have to be careful that the information for the seller and their designated representative remains confidential with that designated representative. The buyer's representative, their confidential information stays confidential to that designated representative. It doesn't get shared amongst the brokerage innocently like it may, but under a brokerage representation agreement, it can be shared, not under designated.
The Q&A function is going wildly in with regards to this topic of multiple representation when practicing designated representation. So let's set the record straight. I'm the designated rep for a seller. I'm the designated rep for a buyer who wants to buy that seller's property. Is that multiple rep?
So multiple rep occurs whenever the agent, and if it's brokerage representation, it's every agent. Under designated, it's that particular agent. Whenever more than one client is being represented in a transaction, that is multiple representation. It can be seller and buyer. It can be the competing buyers. If under designated representation, the same designated representative, and if you have more than one as a designated representative, it just takes one of those to also be on the other party's representation agreement for multiple representation to occur.
So in designated rep, I'm the listing designated rep for a seller. I'm the designated rep for a buyer. That's designated rep, even though each client is a client by way of a designated rep agreement. So same agent for a seller and buyer pursuant to a designated rep agreement, we've got multiple rep. The only other time multiple representation occurs in designated representation, Leanne, is, as you said, when, let's say you, by way of example, have two offers from two buyers for a property that maybe is not even listed with your brokerage. That's correct, right?
That's correct. That's the one agent with more than one client. And it doesn't have to be seller and buyer. It can be competing buyers.
And I emphasize this and I bring this up again because it is a question that I receive at OREA every single day. There's still some uncertainty as to how multiple representation is created when practicing designated representation. So here's a question that we get while we're on this topic of multiple rep, Lee, when we have realtors practicing as a team. So let's walk our members through this. How does multiple representation work when we're working with teams?
So when you're completing a designated representation agreement and there's a team, you can't put Team Ferris as the designated representative. You must identify them individually by name. So if you want to avoid multiple representation when you've got a team, you can identify certain team members representing sellers, and other team members representing buyers. You can split the team in two, and that will avoid multiple representation. But it's the names on the representation agreement that matter. It's not the team name, it's their individual names.
Excellent. And I suspect we have a piece in the hub about designated representation. As a matter of fact, I know we do. And for a deep dive on this particular topic, if you're still struggling with it, again, check it out at orea.com/the hub. There it is.
That's our multiple representation one we mentioned earlier. But there is also one on representation agreements and designated representatives.
And if you guys haven't checked these out yet, I can't emphasize how quick and easy these are to read. Like if you're waiting at a listing for a buyer to show up, these are 5-10 minute reads at the very most, and they're incredibly helpful and easy to understand. All right. I just jumped in the chat, Leanne. There were a lot of questions. People are jumping to disclosures. We'll get to that in a few minutes, guys, I promise you. Right now, we're going to introduce a brand new agreement. I gave this a shout out at the beginning of today's webinar. Now we're going to get to it. So we all know that when we practiced REBA, we were able to sign an agreement with a self-represented seller, a FSBO, so that FSBO, that self-represented seller, could pay us. We all know that that's no longer allowed pursuant to TRESA. Remember, all agreements must contain representation as per General Regulation 13.3.1 within TRESA. So no longer can we have a self-represented seller, a FSBO, sign an agreement with the brokerage for the sole purpose of paying us when we simply present them with an offer. And for the previous year, this has proved incredibly challenging for us as Ontario Realtors. The advice provided has been, in the example of having a buyer client interested in buying a FSBO, a self-represented seller, to ask that self-represented seller to enter into a representation agreement, sign a listing agreement. However, that came with the creation of creating multiple representation, doesn't it? Now you've got a buyer client, the seller signs a listing agreement. Now you've got a seller client, you've created multiple representation. And maybe the buyer and seller didn't want to be in multiple representation because, as Leanne and I explained previously, the clients involved in multiple rep must consent. If they don't, you can't act in multiple rep. So OREA has came out with this brand new form that will help you collect commission in those situations where maybe one of the parties is self-represented. I think the most common example is the FSBO example. Now, before Leanne walks us through completion of this form and the three main parts of this form, the meat and potatoes of this form, I need to emphasize, this is not an agreement between the real estate brokerage and a consumer, a client. This is strictly an agreement between the parties to a transaction, a buyer and a seller. So I repeat, this is not an agreement between the buyer and seller with the brokerage, or a seller and the brokerage, or a buyer and the brokerage. This is strictly between the parties to the agreement. Did I emphasize that well enough, Leanne?
I think you did, Ray. It's vital, and this is key to understanding the commission agreement, is that it is not an agreement with the brokerage. It's an agreement between the buyer and the seller.
So let's use an example where a buyer client comes to me and says, Ray, I want to buy that self-represented seller's property down the street, the FSBO. They had an open house on the weekend. I went to it. I want to buy it. I'm not comfortable buying it directly from the FSBO. I want you to represent me. So how can we use Form 223, Leanne, in a situation like that, where the buyer doesn't have enough money in their pocket to pay my commission because they're using all of the money that they've saved up for their down payment. They've got 5% and a few $1,000s extra for legal fees and new appliances. They don't have thousands of extra dollars for commission. How can I use 223 in that situation?
Well, you could approach the self-represented seller and ask in advance, if I brought you a buyer, would you be willing to pay my brokerage a commission? And you could discuss the amount of commission that seller is willing to pay your brokerage. And remember, whether it's in writing or not, you're representing that buyer. Otherwise, you couldn't be working in this scenario. So hopefully you've got a written buyer representation agreement identifying what that buyer has agreed your brokerage should be paid for assisting them, representing them in a purchase. So when you're putting this form together, you're not disclosing the buyer's name up front. You can have a conversation with that seller, disclose to your buyer the terms that that seller has agreed. That buyer can then make a decision on whether they would like to place an offer. Because if there's deficiency, the buyer's obligated under their buyer representation agreement. So if the buyer is then agreeable to placing an offer, you can go back and have this commission agreement generated between the seller and the buyer, identifying the amount of commission that the seller is willing to pay to compensate you representing the buyer. We also show a clause, and we're going to expand this clause on the next slide. The clause that needs to go into an agreement of purchase and sale. I'm sorry, I guess it wasn't the next slide. I lied. There's a clause that we will be showing you shortly. I really messed you up on this one, right?
Oh, that's
Sorry
fine.
about that.
We know this material so well,
Yeah.
we're just jumping so far ahead.
I'm so excited to talk about the clause. So there's a clause here that we're going to insert on the agreement of purchase and sale to identify this agreement that's been made between the buyer and the seller. So on the next clause, or on the next screen, Ray's shown you why we actually need that commission agreement, and that's because any agreement you have with the buyer or the seller for the purposes of trading in real estate has to include representation. So this is not an agreement between the brokerage and the seller. It's an agreement between the buyer and the seller.
So I like to explain this new Form Leanne 223 commission agreement as a request made by the buyer of the seller to pay the buyer's real estate brokerage for bringing an offer to the seller. Like it's really just a request of the buyer to the seller in our example here. And the form is a one-pager. It's relatively easy to fill out. It's incredibly easy to fill out, where you just fill in the fields, who the buyer is, who the seller is, who the real estate brokerage is, the amount of commission that the buyer is asking the seller to pay. And then Leanne is referred to the clause that we're going to show everybody in a minute. And Leanne, when do we use that clause? So we're going to only insert that clause in the agreement of purchase and sale when the deposit amount isn't sufficient to cover the amount of commission, correct?
That's correct. And on this form, it says, if the deposit isn't sufficient to pay the brokerage's commission, then this clause must go in the agreement of purchase and sale. And most times, it's probably going to go into your agreement of purchase and sale. I believe most times the deposit may not be enough to cover commissions.
But where the deposit is enough to cover the commission or greater, you will not need the clause that we're going to show. So before we get to that clause, Leanne, let's make sure we've covered all our bases here. We've talked about why we need that commission agreement, and that's as a result of General Regulation 13.3.1. I've talked a lot about the most common example where we use the commission agreement, and that's where we have a buyer client and we have a self-represented seller, otherwise known as a FSBO. Are there other times, Leanne, where we might find this agreement beneficial or helpful?
Yes, if you take a look at the next slide, Ray, we talk about mere postings. So this is where it's already listed with a brokerage. It's on the MLS. They tell you go directly to negotiate your commission. rather than entering into a second listing agreement with that mere posting seller, you can use the commission agreement between the buyer and the seller. And then the third instance on our next slide talks about new home builds, and that's very common, where you would want a commission agreement. The builder may have their own, but be very careful. It probably doesn't comply with TRESA because there will be no representation in that agreement between the builder and the brokerage. So you would want an agreement between the buyer and the builder, the seller, rather than with the brokerage.
Awesome. So we're going to, let me just advance here. I'm distracted by being in the chat. So at this point, Leanne, while I monitor the chat, would you be so kind as to walk us through how to complete the commission agreement? I know we've probably already talked about it. I know I stole your thunder, but that'll give me a chance to dive into the chat while you one time more walk us through this agreement.
Ray, if you can advance the slide for me in about 5 seconds, or right now is great. So we looked at the form. Where the red arrow is, it's showing you the clause that needs to go into the agreement of purchase and sale. So in your standard clause booklet, we have that clause for you. And this goes in, you identify the brokerage. It identifies that the unpaid balance, so that's where the deposit didn't cover off the amount of the commission. It identifies here that the seller will direct their lawyer to pay the outstanding balance of the commission plus HST to the brokerage out of the proceeds of the sale. So you're not going to send an invoice to that seller. This is directed within the agreement of purchase and sale. And remember, if there's any default after this has been inserted into the agreement of purchase and sale, the buyer and the seller decide they want to amend that agreement of purchase and sale, and this clause gets taken out or amended. It then reverts back to what you have agreed to with your buyer in their buyer representation agreement. So it would be detrimental to the buyer to amend something that they've agreed to in the agreement of purchase and sale.
Excellent. Let us look at the next slide, because I was hoping that it would be this promotion of the hub again. And this is another guidance piece strictly with regards to collecting remuneration by a self-represented party or a mere posting. All of those things and more that Leanne and I just discussed. So I would strongly recommend, if you find yourself in a situation that we've described where you're working with a self-represented seller or a mere posting or a builder, you take this deep dive into this guidance piece on the hub. We're now going to shift gears to disclosures. Leanne, I just scrolled through the chat, and most of the questions we've answered along the way. We'll get to some of them at the end of today's presentation. I saw a couple where they were being asked more than once, but we really do need to get to this very important topic of disclosures. Why do I say this is so very important? Well, the way we make disclosures when TRESA came into effect changed. There were lots of disclosures required in REBA. A lot of those same disclosures are within TRESA. There were maybe some new ones added, but the real takeaway from disclosures from within TRESA is how we make those disclosures. By way of reminder, there's two key main elements when we make disclosures in real estate pursuant to TRESA. The first is that when we make a disclosure, there must be prominent placement of the word disclosure within the document. Naturally, one would assume that the word disclosure is in a big, bold font, in a font size larger than any other text size throughout the document. Disclosure at the top certainly is clear and prominent, isn't it? The other second part of the disclosure regulation is that the disclosure being made must be clear and obvious. I like to say that the disclosure being made jumps off the piece of paper and captures the attention of the reader. That is to say, it can't be buried. A disclosure cannot be buried in the body of a schedule to an agreement of purchase and sale, because that's not clear and prominent, because that disclosure is surrounded by a bunch of other text. Members say to me, Ray, we've always used the SPIS to give to a buyer where there's disclosures made on that SPIS. Can we continue to do that? And the answer is no. Prominent placement of the word disclosure is not on the SPIS. And probably more importantly, there's 20 questions per page on the SPIS. That one disclosure in that one question isn't clear and obvious because it's not jumping off the page to get the attention of the reader. That's really what changed with disclosures. So what Leanne and I are now going to do is walk you through a brand new form that we introduced in 2025. It's called 602. The title of the form is disclosure. And see that? The word disclosure is clear and prominent. It's very bold. So that satisfies the regulation within TRESA pertaining to disclosure requirements. And OREA has crafted this form to help you make some of the required disclosures that are required pursuant to TRESA. So, Leanne, while we're talking about disclosures, how do I know if the information is in fact a required disclosure, or is it just information?
Your answer comes right within TRESA. Take a look at how they've worded what your obligation is. If it is a disclosure, then you will read that you are required to disclose this fact. If it's information, such as how many competing offers do we have, the legislation does not use the word disclose. What you'll see in that one in particular, it says communicate the number of competing offers. So disclosures, a lot of obligations and specific way to make those. Communicating the number of competing offers, that can even be done by text or email.
Awesome. We're getting close to the top of the hour, Leanne, so I'm going to plow forward. Let's at this time talk about a discipline decision and the very expensive lesson that resulted when something went wrong with regards to competing offers. So in this particular situation, the listing agent advised that there were no competing offers. Excuse me, I read that wrong. There are competing offers rather. So let me start again. The listing agent tells you there are competing offers, but in actuality, there were no offers. So the buyers, your buyer clients, offer more than the asking price based on being told that there were competing offers. The listing agent then allows the offer to be presented to the sellers, and the sellers accept the buyer client's offer. After the fact, the buyers discovered that there were no competing offers. So these are obvious violations of the code of ethics. The lesson here is that the cost of doing so was $14,000. So let's leave that there and dive back into the required disclosures. I've set the table already for the answer to this question, Leanne, but let me ask it again. Can I make a required disclosure by emailing you or texting you?
Ray, that's not going to likely comply with TRESA. Communicating the number of offers, as I said, that can be done any way that you want to communicate it. But this section under TRESA for disclosures clearly identifies that it's not going to work. It's not going to satisfy your obligations if in fact you do a disclosure by email or text.
So if I'm selling my mother's property, is that a required disclosure?
Absolutely, that's a disclosure of interest.
So
and that would actually be an indirect interest.
So what you just said, Leanne, in response to this question, if I'm selling my mom's property, I can't email and say, oh, by the way, Leanne, this is my mom's property. That's not going to cut it, is it?
No, it's not. And you would use OREA Form 161 to make that disclosure.
So let's talk about the disclosures. And I think we talked about this already. Do we need to disclose? Sorry, we didn't talk about this already. Do I need to disclose if one of the buyers in a competing offer situation is from the listing brokerage. So by way of example, Leanne, I have a property listed for sale. I'm the designated rep for the seller. You, who work at the same real estate brokerage with me, represent a buyer. You've got a designated buyer representation agreement with that buyer. The buyer and seller are each represented by their own designated rep. So first, is that multiple rep? No, it's
No.
not, is it?
No,
So in that situation, Leanne, do I have to disclose as the listing agent that the buyer made an offer from a representative from our firm?
So the obligation changed under TRESA because it used to relate to multiple representation because it was all brokerage representation agreements. So this now changed under TRESA, where a brokerage is providing services to both the seller and the buyer. Not representing, but providing services. When there are competing offers, you must advise all competing buyers that the brokerage is providing that service to both the seller and one of those competing buyers.
And the first checkbox on our new Form 602 does just that, doesn't it?
It does.
And we've illustrated an example on the screen for everyone. So in this particular situation where the buyers in a competing offer situation are from the listing, are being represented by the listing brokerage, you check off checkbox number 1. Let's look at the next example. Let's say there's a commission reduction. The buyer's agent agrees to accept 1 point less. But there are no competing offers, Leanne. Is this a required disclosure?
It's not required unless there's competing offers. So once there's competing offers and there's a commission reduction that impacts whether the seller would accept an offer, that disclosure has to be made.
And I'm going to use checkbox number 2 to make that disclosure, right?
Mm-hmm.
All right, let's go to another one. Very common example. I've talked to hundreds of members in the last couple of weeks since our previous webinar about this particular topic. So let me introduce the topic of interest-bearing trust accounts, Leanne. So first, when a brokerage earns interest on a buyer's deposit, that in fact is a required disclosure under TRESA, isn't it?
It is. And actually, whether you receive interest or not, the terms on your depositing the buyer's deposit is a requirement. So on the agreement of purchase and sale, where it talks about the deposit, it already says without interest. So you complied with TRESA. If in fact it is going to be interest bearing, that's where additional steps need to be taken.
So historically, Leanne, realtors have inserted a clause on the schedule in the APS that says something like the buyer and seller consent to the listing brokerage earning interest on the buyer's deposit. In light of the disclosure regulations within TRESA, I think that doesn't cut it anymore, does it?
It doesn't. You don't have a prominent word of the of disclosure. It's not prominent. And did that clause jump off the page like Ray described? No, it's muddled in with a supplementary deposit with the buyer. So
we're going to use our brand new form for that disclosure, aren't we?
We are. So 602, it's the third section now that you're completing. It's going to contain the information that you generally did put on a schedule to the agreement of purchase and sale. But this is now the format to take to make that disclosure.
So it's happening in the chat right now. Members are saying to me, but Ray, this disclosure document is between, in our particular example that we've shown here, only the buyer. The seller has not consented on this disclosure form. Therefore, we prefer to use the APS, the schedule, because we can put a clause in there that the buyer and seller are aware and agree and consent. So why, Leanne, is the seller not on this disclosure document when we're talking about interest-bearing trust accounts?
TRESA has written that you must disclose to the person making the deposit the terms. It does not say that you must get consent from all parties.
So when a deposit is made in a real estate transaction, Leanne, that is the buyer's money. Once it's put into a trust account, that still remains the buyer's money. So that's why the regulation pertaining to interest-bearing trust accounts strictly refers to buyers only. Now, let's say the seller during negotiation says, you know what? That's a significant size deposit. There's going to be significant interest earned on that deposit. I want the interest. I, as the seller, want the interest. And the buyer agrees. Does that change anything?
What that requires then is something in that agreement of purchase and sale, identifying that someone other than the buyer is receiving the interest on that deposit, because TRESA says is paid to the beneficial owner of the money unless otherwise identified in that contract.
All right, we're up against the clock. We've got 4 minutes left, so let's plow forward. When would I use OREA's clauses pertaining to an interest-bearing trust account? And here they are, Leanne. I'm going to let you walk through this while I go back in the chat.
Okay, so these are just acknowledgements. You see that this is just putting in the agreement of purchase and sale, an acknowledgement that this is what's going to happen with the deposit monies. This is not the disclosure. You do not see the word disclosure anywhere. So this would be in addition to providing that disclosure form 602, just reiterating it into the agreement of purchase and sale.
Excellent. Let's fast forward. Very common question. How in the world do we as realtors know, Lee, what a material fact is?
It's defined under TRESA. It basically is anything that impacts a buyer or seller's decision to buy or sell and the price paid. That's a material fact. It's personal to them. The next slide, we give you a few examples of.
Before we look at those examples, Lee, I want to ask you a question that I hear. I'm a buyer's agent. How in the world do I know what's important to my buyer?
You have to ask the questions, because what's important to one buyer may not be important to another. And at the end of the day, your opinion doesn't matter. It's what's important to that client in determining what a material fact is.
And I think there's even information in Rico's information guide that says to clients, look, you need to make your realtor aware of what's important to you. But our obligation doesn't just stop there by giving them the info guide. We literally need to say to our clients, is there anything in the case of a buyer that would turn you off from buying a property? It may be something like a buyer doesn't want to buy if there was a death in the home, right? That's a material fact that's important to that individual buyer client. The lesson here is we need to ask. We need to literally ask our clients what's important to them. So Lee, take us through what our obligations are with regards to material facts from within TRESA.
It only has a slight change from what was under REBA. You still must ask the questions, discover what a material fact is, and disclose it to your client. What's new under TRESA is you now have to advise them to think about what you just told them and really think about whether it changes their decision on what it is that they're going to offer on the property, if at all. And then what else is, you need to get, wherever possible, an acknowledgement that you've made that disclosure to that client. So once again, we're back to form 602. One of the options on that form is disclosing that material fact. And we've got an example down here that the vacant lot has this particular zoning on it. That could be a material fact.
Very good, thank you. Can you give us some other examples of material facts really quickly?
Yeah, it's anything. It's, you said a death in the home. It could be, is it a haunted home? Property uses. What are the municipal services? Are you actually set with water and sewer, or do you have a septic system? It's anything and everything.
Thank you, Lee. I'm going to gloss over this discipline decision in the interest of time. I think this is a really important slide. I mentioned that I think there's 11 disclosures that are within TRESA. This form lets you know, if you look at the middle column, what all of those required disclosures are as a result of TRESA. And then in the left-hand column, We've indicated for you which form actually is required to be used or you can use from the toolbox, from OREA standard forms to help you comply with that required disclosure. And again, we've got a guidance piece in the hub strictly about member disclosure obligations.
And Ray, if I can just jump in, that chart that you just showed on the screen prior to that this chart is found within that member disclosure obligations guidance piece.
Excellent. I've actually printed this form off, hung it on the corkboard above my desk so I can quickly reference what are my required disclosures if I forget, and which form do I quickly reference to make that required disclosure. So, guys, I'm going to wrap up. I'm going to direct you to OREA.com, OREA.com/standard forms, where you can get all kinds of additional resources from OREA. There are guidance pieces called the Hub. There is a catalog of all of the forms that OREA has for you to consider using in your practice. There is a clause booklet that has all of OREA's 332 clauses that you may consider using in agreements of purchase and sale. So you can find that, as I mentioned, at OREA.com/standard forms, or if you want to go directly to those 24 guidance pieces in the hub, it's OREA.com/the hub. And in closing, I just want to say, we'd love to hear from you, not only your questions, but suggestions. If you have suggestions for future hub articles that you would like authored, let us know. And in closing, we were overwhelmed in the Q&A with questions about a real estate brokerage website. I'm not going to mention the name of the brokerage, but there's a real estate brokerage that operates a VAL and allows consumers to see the sale prices of property. The suggestion in the Q&A is that these are just publicly available. However, I could stand to be corrected, but the proper operation for that real estate brokerage is that if you are seeing that sold data on their website, it's because you've signed up and agreed to their strict rules. What you're seeing in terms of sold price on their website is behind a username and a password, I would hope. If that's not the case, let us know, but that is what is required. And one more thing, we mentioned it briefly. We said that some real estate boards are allowing sold prices to be posted on realtor.ca. That too is consent that is required from the buyer and seller in that particular scenario. So again, guys, standard forms at OREA.com for your questions, your comments, and your suggestions. Thank you very much. We tried to answer as many questions as we could throughout today's presentation. Have a great day.